Welcome back to the Emily Show, Quick Bits, the Monday Show, whatever we're calling it, because quicker than a live stream, but what's our definition of quick these days anyway? It is Thanksgiving week, but of course the law does not take a break, and right now, neither do I. So we should just get into it. There's a ton to talk about today. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Today, we need to do another Real Housewives of Orange County fact check, EDB style. We're going to talk about that. A few cases that are a blast from the past because the Supreme Court of Illinois turned over Jussie Smollett's conviction. One of the still outstanding Ethan Klein H3H3 lawsuits finally settled. Plus, there's more going on in the Diddy case, and Laken Riley's killer was convicted and sentenced. That was a court trial, convicted by the judge. We'll talk about that briefly. Before we get into all of it, I would like to say a huge thank you to all of the law nerds that made the launch of Law Nerd Shop 2.0 such a success. If you have not checked out the new store design and the new designs available in the store, please do go check it out at lawnerdshop.com. Yes, some of the items are sold out, but we will be able to better anticipate our next launch, and there will be new launches coming in the new year. There are no new launches coming for the rest of this year, but we have heard you, law nerds. Don't worry, we're bringing in all kinds of new designs and different product varieties, but for the first launch with an entirely new shop and an entirely new distribution system and sourcing, we went with these designs, and I hope you love them as much as I do. I love our new Law Nerds Rock hat. It is incredibly soft and very comfortable. Everything was sourced with softness in mind. It's huge for me, and things that just feel cozy. And on that, there are no tags in our sweatshirts, so when you get your hoodies, you will notice that there is a new Law Nerd Shop logo in the back of the hoodie, and I love all of the little touches that we were able to add in to this customized launch just for you. I can't wait to see all of you tagging me on social media with the things you got from the shop. So first, Emily, it's time for a fact check. Yes, let's fact check me. Last week, so many of you shared after I talked about the Shannon Beador, John Jansen, Alexis reunion of it all. And yes, the trailer definitely had a franken-edit. So in the trailer, it very much seemed that Shannon was talking about the facelift lawsuit. And in the episode that I watched after I recorded Quick Bits, it was very clear that she was talking about the Jim Bellino lawsuit. For those of you who are like, girl, what? Yes, Shannon Beador was sued by Jim Bellino. If you do not watch Real Housewives of Orange County, this is going to feel like I'm explaining to you junior high school drama of a bunch of people that you don't know. Just roll with me. Shannon Beador was sued by Jim Bellino years ago for defamation. Shannon Beador won that lawsuit on an anti-slap motion. He had to pay some of her legal fees. This season of Real Housewives, she talked about the fact that that cost her over like $300,000 in legal fees. Yes, she recovered some of that. He was ordered to pay her over $100,000 in her winning the anti-slap motion and having him being ordered to pay legal fees in that case. At the time, Jim Bellino was divorced or divorcing Alexis, who is now on this season again of Real Housewives of Orange County. Alexis, it seems, was reaching out to Shannon, texting that she's going to get sued and that we are suing you. We referring to her and Jim Bellino. The twist on that this season is she's still talking about we are suing you, but now we is Alexis dating John Jansen, who had previously dated Shannon for 4+ years while Shannon was filming the show. Of course, we know that John Jansen sued Shannon Beador for over $75,000 regarding money that he said was lent for a facelift. During this season, it came out that maybe that was a loan. Shannon had said it was a gift, but there were some digital trail of whether or not that was in fact intended as a loan, not as a gift. Either way, Shannon says she offered to settle it, but wanted a non-disparagement. That is very common in legal settlements, that it's, we're settling it, the settlement's confidential, and keep my name out of your mouth. But apparently John Jansen didn't want to do that. He definitely got his airtime on this, but also I'm sure he was concerned, looking at it through his lens, that she was going to be on the show talking about him and that he doesn't have a platform like Bravo to talk back. Well, he has talked back, and now all of this is settled. He maybe had his final say at the reunion episode where he was recorded separately from the reunion to make statements about the lawsuit, which right after the reunion, it dropped that that lawsuit had settled. And of course, that notice of settlement appeared on the public website after I recorded last week's Quick Bits, but I think right before the final episode of the reunion aired, which of course was recorded in advance. So I wonder if everybody having their say is what allowed them to finally resolve this. And then Shannon dropped an Instagram story showing a wire transfer. She tagged John Jansen and Alexis Bellino in that photo, and the wire transfer photo, mostly redacted, but photo that she shared says John Jansen's settlement in full and shows the amount of $60,000. So settled for somewhat less than what he was seeking, but also settled for less than either of them are going to pay if this thing went to trial in legal fees, right? So at the end of the day, Shannon won the Jim Bellino lawsuit. She settled the John Jansen lawsuit. And whether there will be more lawsuits, we will see. But if you're going to be on reality TV, at what point does it become not worth it if you are going to get sued over shit? These are incredibly expensive lawsuits. And sometimes at the end of the day with civil suits, no one ever feels like they won. Money changes hands, lawyers make money. But at the end of the day, does anyone really feel like they won? So the Bravo franken-edit on the trailer totally got me. I was sucked in. Look, it happens to me every Housewives franchise. And, you know, I'm dying to see what's playing out in Salt Lake City. And we're getting back into Beverly Hills. And it seems like maybe they were filming at the time that Tom Girardi went to trial. And I can't wait to see what happens there. Tom Girardi is supposed to be going to sentencing at the beginning of December, but his lawyers are again trying to put that over, and his lawyers are trying to have the court reconsider his competency. I don't think that's going to fly, but we'll circle back at the beginning of December on that. And speaking of lawsuits settling, I covered quite a lot when this went down, the H3H3 Ethan Klein podcast lawsuit by Triller. Some of you who are new here might be like, who? Triller. Yeah, it was an app. They had also done a Jake Paul fight. I don't even know if the app is still around, but they had done a Jake Paul fight, and Ethan Klein had showed clips of that Jake Paul fight on his channel to give commentary after the fight aired. They ended up settling this lawsuit. When I covered this originally, I'm like, this is going to be difficult for Triller to win. However, it's going to be expensive AF for everyone involved. Sometimes lawsuits settle because the legal fees just aren't worth it. And Ethan Klein mentioned recently on his podcast that that settled for around $3,000 that he paid to Triller. I think in the long run, he probably would have won that copyright lawsuit. However, it would have cost him a substantial amount more money than $3,000 to win a federal copyright lawsuit. He is not a stranger to copyright lawsuits and so far has not lost any. But it was interesting to see that Triller lawsuit finally come to an end in federal court. It seemed like it was going that way with how long it had been with both parties putting over any real litigation in the case, so I'm not surprised there. And then I am still keeping an eye on that final lawsuit that he has going on with Ryan Kavanaugh, which is also a defamation suit. So we'll circle back to that probably in the new year. And also winning in court is Jussie Smollett. Let's talk about it. You might remember the conviction of Jussie Smollett. He was tried for essentially a hate crime hoax, and he was also ordered to pay a substantial amount of restitution. I believe that there were also civil lawsuits between the city and Jussie Smollett over the extensive amount of overtime that was paid. The heart of this appeal was about due process and about double jeopardy. There were many grounds that Smollett had appealed on. Those appeals had been denied repeatedly. That's how his case ended up in front of the Illinois Supreme Court. I had actually covered that on the podcast more than 2 years ago. He was convicted after a trial, and then he appealed. Part of his argument on appeal was that he should be allowed out of custody while pending on the appeal, and he was in fact allowed out of custody because the sentence would be shorter than the appeal would take. And then after his appeal was denied, he was ordered to finish that 150-day jail sentence, and then he and his attorneys appealed it up to the Illinois Supreme Court, and on November 21st, 2024, the Illinois Supreme Court sided with Smollett and overturned his conviction, which means that that conviction will not stand. And I am sure there are some around the internet that have called this a technicality. However, I don't think that the due process grounds are, in fact, a technicality. They are a constitutional protection. Let's talk about it real quick because the reason that Jussie Smollett's case was overturned is very similar to the reason Bill Cosby's conviction got overturned. It is a very similar situation, though I think the Cosby situation, from my perspective, was much more egregious on the part of the district attorneys. In the Smollett situation, I think it was a much closer case. The defense argued successfully that when Jussie Smollett agreed to forfeit his $10,000 in bail for a nolle pros, which means a we will not move forward with the case, that was him relying on the district attorney's office saying they weren't prosecuting the case. And based on that bargain between the defendant and the prosecution, he should not have been prosecuted again. Prosecutors say that they were not bound by that agreement because hands had changed at the prosecution office and they said they shouldn't be bound by the former prosecutor's deal. However, that is exactly what happened in the Cosby case, though. In that case, he had relied on that representation by prosecutors, had given depositions because he no longer had a Fifth Amendment right. And then prosecutors decided to prosecute him later and use those depositions against him. So in Cosby relying on the representation that he was not going to be prosecuted and that he had no Fifth Amendment rights remaining because he was not being prosecuted, he then got prosecuted based on things he said, relying on the deal from the prosecutor's office. Different here than forfeiting $10,000. However, the court did make that analogy as well, and in their conclusion said, quote, "We are aware that this case has generated significant public interest and that many people were dissatisfied with the resolution of the original case and believed it to be unjust." They are talking about the refusal to prosecute, or the nolle pros, in the original case. Nevertheless, what would be more unjust, they say, than the resolution of any one criminal case would be a holding from this court that the state was not bound to honor agreements upon which people have detrimentally relied. As the Supreme Court of Pennsylvania recently stated when enforcing a prosecutorial promise not to prosecute. And that's the Cosby case. And they quote the Cosby holding in the Pennsylvania Supreme Court saying, quote, "It cannot be gainsaid that society holds a strong interest in the prosecution of crimes. It is also true that no such interest, however important, ever can eclipse society's interest in ensuring that the constitutional rights of the people are vindicated. Society's interest in prosecution does not displace the remedy due to constitutionally aggrieved persons." That court further noted that the consequences of failing to enforce prosecutorial promises when a defendant has relied on them to his detriment, quote, "A contrary result would be patently unfair. It would violate long-cherished principles of fundamental fairness. It would be antithetical to and corrosive of the integrity and functionality of the criminal justice system that we strive to maintain." The court says, in sum, "We reverse the judgment of the appellate court, reverse the judgment of the circuit court, and remand the cause with directions for the circuit court to enter a judgment of dismissal. Judgment reversed, cause remanded with directions." Now, when this was originally argued, the defense was arguing mostly double jeopardy and a little bit on the grounds of contract and reliance on the contract, which is exactly what we saw in Pennsylvania. He went ahead and forfeited that $10,000. That was a detrimental reliance, and the court, like most appellate courts, favors results that promote consistency. And I think we're going to continue to see this, and it's understandable. If a prosecution office promises one thing, and then a new prosecutor comes in, or a special prosecutor comes in, or hands change due to an election, you shouldn't worry then as a defendant that because the past office promised something, that the new office is going to go ahead and revoke that and move forward with something. So I think we are going to see this continue, and I think it is a notice to prosecutors that even though they might not stand by what previous prosecutors decided, they need to be very careful in how they proceed, not only with offering deals, but with revoking those deals if they choose to. Also, what is clear here is that the detrimental reliance in some way, which again, we saw in both of these cases, is a critical factor here, different than like the Baldwin case when the special prosecutor agreed not to prosecute the case while the investigation was pending and then reinitiated that prosecution after the investigation completed. that was a different situation. And we've not ever seen Baldwin assert that he detrimentally relied on that dismissal and then did something that would then be to his own detriment down the road. Again, it's understandable that appellate courts are going to go for consistency, and when the hands of prosecution offices can change, you shouldn't have those deals changing to defendants that have detrimentally relied on them. So with that, the Smollett prosecution is done, the conviction is overturned, and that is the end of that, though civil suits may still move forward with regard to how much money he may owe the city due to the overtime spent on this hoax. It doesn't undo the fact that that's what a jury found. And for a civil lawsuit, that may be enough. The way that the conviction was obtained is what the problem is here. In talking about convictions and sentencing, in the Laken Riley case, the court did convict her killer of all 10 counts against him.
Couple of things before I announce the verdict. I want to point out that typically my role in a trial, in a criminal trial, is to manage the process. And the fact finding is done by a jury. That wasn't the case in this trial. I managed the process, try to, and I was also the finder of fact, and that is somewhat of a different role than we typically see. I'll tell you that you may have seen me, I make notes during the trial. I probably filled up 2 legal pads full of notes during the trial, but the closings I want to just listen, and that's what I did. But I wrote down 2 things in the closing. One was a statement by Ms. Ross that the evidence was overwhelming and powerful. And then I also wrote down what Ms. Beck said, that I'm required to set aside my emotions. That's the same thing that we tell jurors in what and we're giving them their job. That's the way I have to approach this, and I did. Both of those statements are correct. I'll now announce the verdict. In the state of Georgia versus Jose Antonio Ibarra, case SU 24 CR 0323, count 1, malice murder. I find the defendant guilty. Count 2, felony murder. I find the defendant guilty. Count 3, felony murder. I find the defendant guilty. Count 4, felony murder. I find the defendant guilty. Count 5, kidnapping with bodily injury. I find the defendant guilty. Count 6, aggravated assault with intent to rape. I find the defendant guilty. Count 7, aggravated battery. I find the defendant guilty. Count 8, obstructing or hindering a 911 call. I find the defendant guilty. Count 9, tampering with evidence. I find the defendant guilty. Count 10, peeping Tom. I find the defendant guilty.
And then after heartbreaking impact statements from Laken Riley's friends and family, the defendant was sentenced to life. The options in that case, as I mentioned last week, were essentially 25 to life and life, which is life without the possibility of parole, and that is what the judge chose. I will link the court feed down below if you would like to go watch those impact statements. They are absolutely heartbreaking, but it's such an important part of the process because you end up talking, especially in coverage, a lot about the facts of the case and how a victim died, but the impact that that has to her friends, her family, her community, her college community is something that's not really addressed until the end of the case. So that will be linked down below if you would like to watch it. And after all the evidence came out in court, I'm not surprised that the defendant opted for a bench trial here, and I'm not surprised that he was convicted by the court. There was a substantial amount of evidence in this case, and the defense's arguments were mostly narrow legal arguments. There wasn't a lot of room to argue against the facts in that case. And finally, back into court was Diddy. If you didn't see me lose my mind last week when it became clear that Diddy's lawyers might have misrepresented information to the court during the hearing regarding attorney-client privilege, that absolutely happened. And then they were back in court for the bail hearing. If you're like, Emily, what are you talking about? I will summarize in as quick of a form as I possibly can. So all of this centers around the third try by Diddy's lawyers to get him out on bail. In the defense bail motion, they largely rehashed everything that they've said before. I don't even know if that adequately opened up the question of bail. But part of what the prosecutors used in their opposition to the defense motion for bail was information that came from notebooks or legal pads that were photographed after a search of MDC that prosecutors say was unrelated to Diddy, was related to other things, but that the investigator who was searching Diddy's cell and area was working on a separate ongoing covert investigation or knew about that separate covert investigation and took photos of his notebooks. The defense said that the things in those notebooks were attorney-client privileged information, that it came from conversations with the defense attorney. The prosecutors argued, no, these are things he's asking others to do, not lawyers, and it's not privileged, and that it, in fact, went to a filter team or a taint team to be checked to make sure that privileged information wasn't being turned over to the trial team. And they were back in court arguing about that when the defense handed the judge at the bench a legal pad that they said was marked legal at the binding at the top of the pad. And the judge questioned the prosecution about that quite a bit. And the prosecutor said, we don't know when that got there. Well, after that hearing, the judge made an order telling the defense to be ready to explain themselves when they came back into court on Friday, November 22nd for that bail hearing. And the defense responded late in motions regarding the bond hearing, but never really addressed the legal pads after the court had said the photos from the search of MDC don't show any writing on these legal pads. This is legal on the top, yet in court, they handed the judge a legal pad that they say said legal and that prosecutors should have known. There was a lot of fist pumping and hand wagging that prosecutors should have known that this was privileged. So I was waiting to see what the federal court was going to do with regard to that. And per in-court reporting from Inner City Press, the court said to the defense at the very beginning of the hearing, thank you for being here, and then turned to Diddy's head defense attorney and said, tell me about the legal pads. And Combs's attorney said the first time I saw them was Tuesday when he was in court, showing them to the judge. The court said, as we sit here today, I'm not sure when legal was written on each of them. Backpedal, 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 backpedal. I'm trying to get to the bottom of it. Different members of the defense team was telling him to write legal on the pads. There was a photo of the pad without legal writing on it. So they acknowledged the photos the prosecutor had are accurate. And then Combs's lawyer said to the court, so it's clear that on November 1st, the sweep, they did not all say legal. He's still trying to parse it narrowly. And the court said, the pad you handed up to me, did it say legal on it on November 1st? The attorney said, I'm not sure. And the court said, moving forward, make sure representations are true. Attorneys owe a duty of candor to the court, and losing the trust of the court by directly misrepresenting something to them is a very bad position to be in. However, we are very early in proceedings, and while there's a lot more the court could have done here, the defense is on notice. If this comes up again, it is going to be a huge problem for the defense attorneys because, again, while they owe duties to their clients, they are officers of the court, and misrepresenting things to the court is incredibly serious. And the court called it out, saying, make sure representations are true. Look, you can't get lost in the sauce in court, even in the name of zealous advocacy. You still have to represent things truthfully. I will cover more of this hearing and the fight for bond in this week's episode of The Emily Show on Wednesday. Yes, there will be a new podcast this Wednesday because the judge has asked the attorneys to submit further briefing by Monday at noon. So I want to have that briefing before I break this down anymore. And the court said we're going to get a decision out prompt next week. The court has not decided this yet. Courts will be working Monday, Tuesday, Wednesday. Sometimes Wednesday's a half day, and again on Friday. So the only day the courts really have off is Thanksgiving this coming week. So we'll see what we know about this ahead of the Emily Show podcast. And if there is an addendum to it, then I will make an addendum to it. So I will see you for the premiere of that episode on Wednesday. I will see you on Tuesday for a hearing in the Karen Reed case, unless somehow between this getting recorded and Tuesday, that hearing gets kicked out. But if you have the Law Nerd app, then you will know where to stay in the loop and when I'm going live. So if you're getting ready for this week and you just need some court in the background, I'm here for you most of the week. And if you're a member either in the Law Nerd Lounge or on the Emily D. Baker YouTube channel, Dr. B and I will be having a members only stream on Friday, and I will be telling you more about that in your members community tabs on YouTube and in the Law Nerd Lounge. And so we will be chatting all the things with Dr. B on Friday. So I hope you have a good week. It's okay to take it a little bit slow. It's my favorite thing to do this time of year as it starts to get cold outside, is to make sure that I really am taking the break that I need. And during cooking heavy weeks, it's really nice to know that I don't always have to cook. And that is why I appreciate today's sponsor, Factor, so much, because even though I might enjoy cooking one dinner in a week, I definitely never take the time to make myself a balanced lunch. And with over 6 menu preferences, from maximizing protein, finding balanced meals, keto, or even vegan and vegetarian, and 30 meals to choose from, you can find the flavors of the season already made for you and ready to just heat and eat. There's no sacrificing quality for convenience with Factor, and weekly menus offer you a way to treat yourself to a restaurant-like meal experience with gourmet plus dishes right from home. Whether you're looking for a truffle butter filet mignon, look, I'm gonna order anything with truffle butter, to be honest, or a garlic herb roasted barramundi, you can make sure you have delicious, fresh, never frozen meals delivered right to your door so you can take care of yourself without all the time. You know, I'm a big fan of keeping it easy. Head to factormeals.com/QBLawNerd50, like the quick bits, and use code QBLawNerd50 to get 50% off your first box and 20% off your next month. That's code QBLawNerd50, all lowercase, at factormeals.com/QBLawNerd50 to get 50% off your first box and 20% off your next month while your subscription is active. Thank you, Factor, for sponsoring this episode and making sure I always have a warm, healthy lunch. And with that, Law Nerd, we have lots of legal coverage this week. This is getting into the time of year when the courts are really trying to wrap stuff up. It's going to be real busy right up until like that last week of December, and then everything's going to slow down a bit. So we are in the sprint of people trying to get things done before the holidays. And for a bit of scheduling, we also have the Sarah Boone sentencing coming up. The prosecution still hasn't responded to that motion for new trial. Like not even a, Your Honor, lol, like nothing. So we'll see what happens when that comes back for sentencing on December 2nd. I'll be streaming it live over at theemilydbaker.com. And with that, thank you for joining me. I know you guys enjoy the Monday episodes, and I hope you enjoy staying in the loop with all things law. I've got some other TV lawsuits coming down the road that we're going to be talking about on future Quick Bits. So you don't want to miss it. Go ahead and subscribe to this channel too. And I will see you in the next one. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.